Okay, so Owens has filed a new motion as of the 4th, yesterday, end of the day, and he wants a new trial for Sarah. I'm sure we should have seen this coming. We know she can't accept anything other than her own reality, her own narrative. And of course, Owens is going to try whatever he can, but this is complete nonsense. So I'm going to read the motion and we'll talk about it a little bit. So he filed this on the 4th. Defendant's motion for a new trial. Comes now the defendant Sarah Boone by and through counsel and pursuant to Rule 3.6, Florida Rules of Criminal Procedure, files this motion for new trial stating in support thereof the following. 1. The defendant was found guilty. Yes, you were, Miss Boone. As charged of second-degree murder on October 25th, 2024. A grand day. The instant motion is timely filed pursuant to Rule 3.6. Okay. The defendant asserts that she is entitled to a new trial under Rule 3.6 on the following grounds. 1. The court erred in ruling that the defendant was not entitled to court-appointed counsel. This feels like old news, but okay. 2. The court erred in denying undersigned counsel's multiple motions for continuance. That was not an error. That was accurate and well thought out by Judge Kranick, but I'm not surprised no one's put that in there. 3. The court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. Yeah, this aggravates me a lot. He's grasping at straws here, I think. There wasn't an outburst. He made more of a spectacle and drew more attention to the outburst, in my opinion. I watched it live that day during closing arguments. They played the suitcase video. It was understandably too much for Georgia's mother, and she left the courtroom. And Mr. Owens got up in the middle of the video. The lights were dimmed in the courtroom. I made a video about it called Owens Misbehaves. Mr. Owens Misbehaves. I'll link it in the description. But he got up and said, I'm going to have to ask you to leave because his mother was leaned over on another family member, as I don't believe she'd watched the video before, and she's literally listening to her son beg the defendant for his life while the defendant mocked him. So she was understandably upset. She didn't make any kind of loud noises, but she calmly walked out. And then Owens requested a mistrial right then and there. And of course, Judge Kranick, being the amazing judge he is, denied it. So that's what that's about. Moving on. 4. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion, and the state committed prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. I don't agree with that. I'm not really sure where he's basing that. That just seems like an opinion he threw in there. All right, law and argument. Here is the argument 1. The trial court erred in holding the defendant was not entitled to court-appointed counsel. In the above styled and numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking her case. And you knew that, Owens. Undersigned counsel took on the above case because he was concerned that Miss Boone would not have an attorney to represent her at trial. Yes, you did voluntarily do that. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. That's not what most of his reviews say. It was apparent to undersigned trial counsel that Miss Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact to handle any other phase of the trial without counsel. I would agree to that. Both the Sixth Amendment as well as Rule 3.111, Florida Rules of Criminal Procedure, guarantee an indigent defendant the right to appointed counsel. See Bowden v. State, State v. Kelly, and Progeny. I'm not sure what Progeny is. There appear to be two exceptions to this precedence. One, if the defendant physically harms or threatens to harm his or her counsel. I wonder if Sarah did that. I wonder if she threatened to put him in the suitcase or hit him with the bat. If the trial court certifies that the defendant will not be incarcerated if found guilty, i.e. a judge trial, which we know that doesn't apply, should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's right to due process as well as the defendant's right to the assistance of counsel. Yeah, and the court did follow a process. I don't think Judge Cranick took that lightly in any sense. I think that he did his research because he knew what was at stake, and he knew already, based on her letters and her language in her letters, that she was planning to appeal before the trial ever started. So I'm sure he crossed all his T's and dotted all his I's in that 16-page order. All right, moving on. In the instant case, undersigned trial counsel would assert that Miss Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel, and if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that continued quote-unquote misbehavior would result in a waiver of the right to court-appointed counsel. Did Sarah write this and just have James Owens sign his name? Her abuse of quotation marks drives me crazy. She puts quote unquote anything that she doesn't agree with. You know, how many times did she put quote unquote justice system in her letters because she didn't feel that she was getting justice? But it's not just about justice for you, Miss Boone. It's about justice for your victim, whom you took their life. So I'm sorry, I got distracted there. So that her continued quote unquote misbehavior would result in a waiver of the right to court appointed counsel. And I was laughing because she was warned. Judge Wooten explained this to her. Judge Cranick explained it to her. I'm sure Cashman at least had one conversation with her because she brought it up before she withdrew about her losing her rights. So anyway, under controlling precedents, failure of the court to appoint trial counsel can result in a motion for new trial being granted. See Figueroa Sanabria v. State and Wilson v. State and Progeny again. Under controlling precedents, Rule 3.111, Florida Rules of Criminal Procedure, and the Sixth Amendment, the defendant through counsel moves the court for a new trial. Snoopy, what are your thoughts about this? Snoopy thinks it's ridiculous. I mean, I feel like we knew they were going to use this from the beginning. They really wanted the continuance because Owens was new on the case. He had to go through all the evidence, but he knew that, and Judge Cranick pointed that out. You knew that signing up. Yes, you wanted a continuance. Yes, we understand why, but I don't think that they necessarily used all their time wisely. I think he was entertaining all of Sarah's ideas and trying to make her happy more so than let's dig into the evidence and let's make sure we're prepared. And that's his fault for not putting his foot down. And like all her other attorneys before him, you know, that's why they did not work out, because at the end of the day, they didn't do exactly what she wanted them to do. All right, argument 3. The court erred when it denied a motion for new trial due to an emotional outburst in the presence of the jury. I've already said how I felt about this. Completely ridiculous. It was not an outburst, and Owens is exaggerating this. Prior to jury deliberations, the alleged victim really gets me too. I didn't say that earlier. It's not alleged. The victim, it's not an alleged victim when they are no longer with us. He's clearly a victim if he is no longer with us. The alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Underside counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that the failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. Can result doesn't mean it will result. See Nabergal v. State, Smith v. State, and Collin v. State. The court is unable to determine if this outburst affected the jury's decision because no inquiry was made. Under controlling precedents, the defendant is entitled to a new trial. I know I would be mad if I was on that jury and they wasted all my time and then threw it out. And then they're going to have to get a whole new jury if they give them what they want here, which is a whole new trial. That's just wasting too much time, too many people's time. Okay, argument 4. The court erred in allowing the opinion of the state's expert not previously disclosed. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD. After the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively in the expert witness's deposition taken on October 4th, 2024. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for the justifiable use of force in battered spouse syndrome testified to before the jury was improper. The state's expert, Dr. Tanya Werner, MD, admitted she had not listened to the defendant's testimony before the jury before forming her opinion on this ultimate issue of fact. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Braden and Dr. Julie Harper before expressing her opinion. I don't know why she would have had to listen to other evidence before testifying. I don't know if that's really proper. I'm not a lawyer, full disclosure. I have no legal expertise. But why would she need to have heard Sarah and the other experts' testimony before making her own opinion? Because she's qualified to make her own opinion. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. Moutry v. Bethune-Cookman University, Inc. When a witness is asked to express an opinion that applies a legal standard to a set of facts, the opinion testimony is generally inadmissible, Hunt v. State. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. Dubon v. State. This testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury therein. Lee County v. Barnett Banks, Inc. Decision approved. Argument 5. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument. Okay, so this would have been when Mr. J did the closing, Mr. Cacciatore did the first closing, and then Owens did his disaster, hot mess, unorganized chaos, and then Mr. J came up and did a rebuttal. So It was very effective, both Cacciatore and Jay. It was very moving to me. If I was on the jury, especially right there in front of the evidence when he was hitting the suitcase with the bat and saying, you know, the evidence doesn't support the victim getting blunt force trauma wounds from the bat outside of the suitcase. I mean, I hadn't thought about that. So I could understand why they're saying, oh, he made a second closing argument. But I don't think, legally I don't know, but I don't think that really is going to be a lot of grounds. I know Owens has to just throw everything in there he can and see what sticks, if anything sticks. But yeah, I feel like it was just effective what he did. And, you know, it wasn't the outcome he and Sarah hoped for, but it was the outcome that Sarah deserved. So that's how I feel. That's just my opinion. So, and then, of course, it goes on to say the defendant seeks the relief sought herein, as well as any other relief she may be entitled. What relief would you be entitled to? None. None. The state of Florida is the one that is entitled relief from you wasting so many taxpayer funds and citizens' time on this ridiculous matter that you have imagined to be your innocence. You're not innocent. You took someone's life and you have to pay the price. So it's too much. It's, of course she's going to write an appeal. Of course I knew that, but it's just absolutely ridiculous how much she feels entitled to. But there's no concern about what George and his family are entitled to. They are entitled to justice, and truly they're never going to really have that justice because George is not coming back. And that's the cold hard truth of it. And so her entitled attitude is just all the more disgusting because of that. That's just my opinion. I don't have that's just my opinion. That's all I'm going to say. So, of course, she's requesting a hearing. I don't know if they're going to schedule one or if they will just tack it onto the December 2nd, but time will tell. Continue to watch the docket. And thanks for watching. Like and subscribe.